Evening at 6 p.m., January 13th, and I'd like to open the Zoning Board of Appeals meeting for this evening. Next, if we could say the Pledge of Allegiance, if you'd all rise. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, just so everybody knows, this is being televised live on local Mashpee TV. And next, I'd like to announce that board member Richard Jodka has resigned from the board effective December 23rd. Board would like to thank Dick for his years of service to the board and the community, and we wish him well, and we'll miss him. Absent tonight are board members Ron Bonvie and Associate Scott Goldstein. So sitting on tonight's hearings will be our three regular board members, as well as Associate Jim Gould and Brad Pitsley. And Jim, if you'd read the first new hearing, please.
Concerns 146 Ninigrid Avenue. Owner Jeffrey T. Wall requests a written finding under section 174-17 of the zoning bylaws to allow for construction of a 10-foot by 14-foot deck on the property located in an R3 zoning district, map 65, parcel 79 in Mashpee, Massachusetts.
Okay. Somebody here? Yes, sir. If you would state your name for the record.
Jeffrey Thomas Wall.
Hi.
I was just looking to put in a small deck off the side of the house. It's really only conforming lot. What else to say about it. It's just a 12 by 14 deck. Pressure treated 2 by 6, 2 by 8 joists with the mahogany decking on it, 32-inch railing around it to be set on piers on sauna tubes, 4 feet in the ground, and then a slider to come off of the living room to access.
Okay. I think we have some comments.
I have a copy of the inspection comments.
Okay. First one I have here is a butter letter. It says, "Hi, my name is Mary Ann, and I've been advertising Carol Ann Olson in regards to 146 Ninigrid. Following statement," oh, here we go. Let's go a little further down. "I'm Carol Olson, and I own the house across the road from Mr. Wall. I don't object to the construction of the deck, but I do have a related concern. At times, Mr. Wall has placed things in the access road to the beach that runs next to his house that have made it difficult or impossible to get to the beach, especially with a jet ski or a boat. The road is required by Massachusetts law to be open to the public and to provide unimpeded access to the beach. I would simply request that as part of any approval of the construction of the deck, Mr. Wall be required to agree in writing not to block road access in any way, and that this agreement be made an express condition of the approval of the construction of the deck. Thank you." And it's signed Miss Olson. She's too ill to attend the hearing, would appreciate consideration and request. Thank you.
I have no objection to doing that.
Well, it's not,
Jet ski.
yeah, that's not anything that this board can rule on. But,
That's something that,
you know, you're not allowed to block a road anyway.
no. And every time I do, she calls the police.
You shouldn't be doing it anyway.
I'm not doing it. I don't, we had some construction going on that she had a big objection to.
Okay.
We-
Bill, do we have any other comments here? Mm-hmm. Do you want to read the inspections one?
I don't have it. I have another one from that person. I think it's a different person.
Okay, we do have another one. It's from Meredith Chadwick. And she's at 26,
Right here. Canachet.
thank you. It's in a butter of 146 Ninigret Ave. She'll be at the meeting tonight. It's concerned with the deck project, and in a bit, you'll have a say. Okay. We also have something from the inspections department. Okay, 146 Ninigret Ave. The area is zoned R3 and is in the pre-contact archaeologically sensitive area listed as high sensitivity. The applicant is seeking a written finding under Article 174-17 regarding the determination from the board the construction by a 10 by 14-foot deck would increase the non-conformity nature of the home. There's something from Conservation. 146 Ninigret Ave, the Conservation Department, Mr. Wall has an existing permit on file with the Conservation Department for this work. Work may proceed at any time as far as the Conservation Department is concerned. This is from the Board of Health. The deck does not impact the septic system, nor is it habitable space that could be considered a bedroom, so the Board of Health has no comment regarding the septic system. In general, the plan is not drawn to scale and does not have any setbacks on it. The plan that was submitted is a previous plan from Charles Spohr, who has been deceased for some time. The plan should not be bearing a stamp, as he is not representing this plan. How old's the plan? 89, maybe? Yeah, you would need an updated plan anyway.
Surveyed?
Yeah, this is too old.
Okay.
But we can move ahead. We can move ahead anyway. And if it comes to that, we can go from there.
But that's what I have to do before we can go any further, is to go.
Not necessarily.
No, hang on.
Are we missing any other comments?
No. That was it.
That was already read in. All right. I see you have current lot coverage of 23.4%.
Yes, sir.
The lot coverage allowed is 20%. So I'm not sure how you got to 23.4%.
I'm not either,
And I assume that every building on here, every structure has been
That's-
permitted?
yes, sir. Oh, yeah. I got it there, yeah. Oh, yes, sir.
Well, the question comes down to, see, there's some stuff shown here, says was removed. So are the numbers here representing after the fact or before the fact?
Don't know. Doesn't say on the plan.
I don't have that plan.
The plan was originally.
Tool shed removed 5/10/89. This is dated 11/9/89. So is this an indication of exactly what's on your property right now?
Yes, sir.
There's nothing missing?
No.
Gotcha. Well, honestly, I'm not in favor of anything over 20%. You're already at 23.4. That's just my opinion. Does anybody else have any other comments on this?
Well, I think what he's looking for is a written finding, and the burden that has to be met is whether or not it is
More detrimental.
not more detrimental to what exists today. In my opinion, to go from 23 to, what's it going to bring it to?
Yeah, what will it bring it to?
It's another 140 square feet.
So what does that do for the lot percentage?
I didn't figure that out, sir.
Okay, well, it's something that you're supposed to figure out and bring in ahead of time. But it's probably in the,
But that counts as coverage, though, I thought it was just the buildings that were covered.
No, it
I thought
doesn't.
the deck would,
What's here?
I don't know. Maybe you could
Could you
answer a question
approach
for
us,
me.
please?
What is this right here? Is that something that was added in?
The bulkhead? Yes.
That's a big bulkhead.
No, that's not.
4.5 by 12?
Disintegrate.
That's I believe it's a step off of the deck in back of the, yeah.
That's a
It's a
big
step.
step, 4 feet.
Well, it's a platform and 2 steps.
All right, that
It's
makes
two-
more
it's a
sense.
2-foot step, platform and then
So it's a platform going out?
2 feet.
It's off the ground?
Yes.
Okay.
It goes down
So
to
that
the
needs to
patio.
be added to the,
Well, it may be already, because if you take a look at it,
You see, I can see, this is the figure where everybody took their measurements off. You can see all the measurements that were added up to try to decipher.
see, it looks like it's all been redone.
yeah.
So the question comes down to, I was looking to see if maybe there's something you can skim off. You know, replace one for the other. You know, like
Well,
a swap.
it's very hard to make a ruling with a plan that's not accurate.
Well, the plan,
You really need an updated plan.
Yeah, I don't feel comfortable not looking at that plan being outdated and with the comments.
Yeah, I mean, I don't want to cost you any more money, but, you know, you're already at 23.4%. If you add this in, I don't know if it's added in or not. That's a landing and a deck, that would be considered part of lot coverage. I don't know if it's in there or not. I can't answer any of these questions. I'm not trying to cause you more aggravation and cause you more money to get it redone if, in fact, it might not be granted anyway.
I get it refigured and stuff. It's such a small deck, I didn't think it would be a big problem, and,
You're already way over the lot coverage allowed.
it's such a small lot, it's tough.
Yeah.
What is this right here? Is this a garage, a shed, or what's that?
That's the garage. and the
That's a
shed-
garage?
and the shed was removed there. yeah.
Right. And what's
There's
this
a
little
garage-
bump out here?
That's a balcony.
No,
Oh, I see.
it's a balcony. So there's a balcony there?
Oh,
So
I
we
know
don't-
what,
we don't- We don't want to take that into consideration then.
you know what that is? That's a spiral staircase, isn't it?
There's a spiral staircase. from that-
Going up to is there an apartment up there?
An apartment?
Is that illegal?
Oh, yes, sir. Oh, yes.
So the Board of Health knows about it and everything? How many bedrooms do you have?
2 counting that one. This is one.
So this is one bedroom
1 bedroom
and one there.
Right.
Well, what you're showing here, that's already blacked out, doesn't exist anymore, right?
Right. That was the addition that we put on, that's right.
This here is an addition?
Yes, so
So that is here.
that is there, yes, sir.
Okay.
So what would this be?
This-
What's the distance?
10 feet. 10 by 14.
How far from the lot line?
It's only, at 10 feet, it's still only 4 feet off of the lot line.
Yeah, that's-
So it's not even to scale.
yeah.
Because right here, you got here to here is 40.
So in other words, you want to put it 4 feet from the lot line plus add lot coverage.
Well, yeah, the lot line was so, you know, so
I mean, you know, we can't approve this anyway, because it's not accurate. Right now, I'm inclined not to do it, but I'm just one vote. But, so, your options are to spend the money and get it redone and come back and take your chance, or,
Can I put a patio out there, flush to the ground patio?
Yeah, you can put a patio.
absolutely.
That, you know, that's.
You don't need to come and see us for that.
Well,
If it's on the ground,
no, I mean, well, I still gotta come to get the step and the platform and the 2 steps approved though, right?
No.
no, it's already there, isn't it?
No, there's nothing there yet.
Well, how big of a platform you talking about?
Well, it would be what, 5 feet, the width of the slider? The sliders would be 5 feet, so it'd be 5 feet, and then you'd need 3 steps to the ground, so it'd be a platform and 2 steps.
Talking egress ways, yeah. Yeah. I
Well,
wouldn't
I'm not
push
gonna
it.
do anything till the spring now anyway, so. I can
You
read-
really should get an updated plan.
I'm not gonna be able to do anything else to the house, so, if I know that I'm covering more than I can cover, and I'm, you know,
You can certainly put it in a patio. You don't have to come to us for that.
well, I think that's probably what I'll do then, and, I thank you for your time.
Would you like to withdraw this petition, or?
Well, if you guys all wanna vote me down, I guess.
Well, I haven't heard from everybody yet.
We haven't heard from everybody, number
I
one.
would like-
And we can't approve it like this anyway.
My objection is, you've done a beautiful job on where the house is now. I love it.
Before you speak, if you would, come right up to the mic and give us your name and
Meredith
address.
Chadwick, 26 Canonchit Ave. The house is beautiful. I don't know if you've been out, but he's done a nice job on the outside. It looks like a little English cottage. But if he puts the deck on it, it's going to look out of place, number one, and he's going to have more structure on his lot than his land. Also, the building inspector says you have to be 40 feet from every street. I talked to him, and it says it has to be setback requirements from the lot lines in that area are 15 feet from the side, 40 feet from the rear and the front, and if he borders a street, it has to be 40 feet from every lot.
Put a lot.
All right, he borders Ninigret and Canonchit. So that's 40 feet from Ninigret, 40 feet from Canonchit. And his house right now, the corner of his house is not 40 feet from his lot line, number one. I would love to see, because everything else has been surveyed in that area, I would love to see his lot surveyed, not just for me, but just for him, too, to see where his lot lines are. It would help him with Miss Olson, you know, so hopefully we'll get, you know, her office back, and with all the issues that they have together, and I think everybody around, so that's, you know, I love what he's done to it right now. He's got a beautiful patio, you know, it's to die for, really, but to put a deck on, it would just take away from the whole thing. It really would.
Okay, thank you.
Does that other lady wish to speak?
Do we have anybody else that is interested in speaking?
I would like to just
Go
withdraw.
ahead. Okay.
And I thank you for your time, gentlemen.
If you want to come back and you want to pursue it further, get an updated plan.
I gotta buy some more property.
Thank you.
Well, have a good evening.
Yeah, you have to still make a motion.
Have to make a
Close it out,
motion.
still open.
We withdraw this request.
All right. Bill, would you like to make a motion on this one?
Yeah, I make a motion that we withdraw the petition on 146 Ninigret Ave, owner Jeffrey T. Wall, his request for a written finding under Section 174-17 of the zoning bylaws to allow for construction of a 10-foot by 14-foot deck on property located in an R3 zoning district, map 65, parcel 79, Mashpee, Mass., at the owner's request.
I'll second it. All those in favor? Aye. Okay. No paperwork to sign, right? All right, Jim, would you read the next new hearing?
190 Monomoskoye Road. Owner Kevin Kaya requests a written finding under section 144-17 of the zoning bylaws to allow for construction of a 4-foot wide walkway, wooden stairs, and a 4-foot by 4-foot wooden platform on property located in an R3 zoning district, map 114, parcel 41A, Massachusetts, Mashpee, Massachusetts.
Hi,
Hi, Kevin Kerr.
go right ahead.
So we have a lot at 190 Monomoskoye. We've had it since around 2000. We live on the other end of the causeway on Bay Shore Drive. We've had a mooring for our boat there for, like I said, since 2000. At the present time, we, walk across the lot. We do walk across some of the marsh, and we take a kayak out to our mooring for our whaler. And we would just like to, and we do have a floating dock permit, but we would like to put a platform so we don't have to walk over the marsh and access the floating dock that way versus. So that's what we got.
Do you live at 190?
I live at 98 Bay Shore Drive. There's a map in the Ripple that shows my house in relationship to the lot.
On this plan?
In our packet that I did for you guys,
There's gotta be another packet, see if we got something to fold it, yeah.
it showed, I had to do a map that showed where the house was in reference to the lot.
Do you own this land?
Yes, Yep. Absolutely, yeah.
There was some question on that.
Oh, actually, I have a copy of my land court decision right in this file here, if you guys want to take a peek at it. It's
No, I believe you.
It's been land courted, yeah.
So let's go with that.
Do you have something?
Did you find anything?
Here we go.
All right, I'll pass it down.
Basically, my residence that I live at's the other end of the causeway, and the lot where we keep our boats, the opposite end of the causeway. I'm on the square.
Okay, so the screen is the lot in question, 0.29 acres,
Yep.
lot number
Mind
11441A.
if I walk over?
No,
Sure.
go ahead.
So this is the lot where you want to put the dock.
Correct. This is where we live here. This is the causeway, so there's no houses.
So you can't even see that, is that correct?
Correct. I have to walk down the street to get to that point.
We had one very similar to this on Monomoskoye West,
Okay,
about 5 years ago.
yeah.
Well, the guy could not see where he wanted to put a dock. And there was some real concern back then that what happens if there's a dock there and all of a sudden kids are playing on it, somebody gets hurt, and who's looking after the dock? One of the things that came in, and there's a bylaw. Let me pass it down. Here's where he lives. Here's the proposed dock. So we'll pass it down. Let me read some comments.
Sure.
This is from Conservation. It's regarding 190 Monomoskoye Road. The commission approved this project on December 10th meeting. Mr., is it Kayer?
Kayer, yep.
Indicated that he will be using an existing pathway on the parcel to access the walkover structure, and there will be no new pathway created. The work may proceed upon verification that the order of conditions has been recorded at the Registry of Deed and the pre-work on site has been scheduled with the agent.
What's the pre-work on site?
Don't know.
If I may, what does he mean by and the pre-work on site has been scheduled with the agent. What is he referring to in this?
I know we have to meet previous to anything being done, and I think he comes down and checks out to make sure we're, you know, if we need any kind of,
Mitigation,
yeah,
Hay bales, whatever?
hay bales and that kind of stuff.
Okay.
He inspects it previous.
Okay, we have something from the Board of Health. 190 Monomoskoye. Board of Health, no comment required. Just going through all these. Okay. Here's the sticky one. 190 Monomoskoye Road. This is from the Inspections Department. The area is zoned R3 and is in the pre-contact archaeologically sensitive area listed as high sensitivity. The applicant is seeking a written finding under Article 174-17 regarding the determination from the board, the construction of a structure on a lot without a principal building on the same lot is a permitted use. This department does not support such situations within the town of Mashpee. A dock is considered an accessory structure. You cannot have an accessory structure without a main structure. It's the bylaws in town.
Question.
Have I got that right?
Basically, that's where on my end, that's where the problem is. So how do you grant it? And if the board grants it, I would basically make a recommendation that said structure cannot be expanded upon, added on to, without coming back before the zoning board of appeals.
Well, we turned it down 3 or 4 years ago, and I have no reason to actually vote for it. Because there needs to be a principal structure in order to have an accessory structure.
Was this here before? Did I hear something?
There was another applicant.
Oh,
different,
This was back, Monomoskoye West,
you.
probably 5 years ago. Same exact thing.
okay. I thought I was going, what did I miss? All right.
Yeah, we had the exact same thing.
No problem.
And it was right,
No,
it was within 100 yards of where you want to do it.
Right.
And we turned it down just because the bylaw is very clear about what you can do and you can't do on that.
Okay.
Go ahead.
Where would you park your car, Mr. Kaye?
I parked my car there right now.
Where's he parking now?
The plot plan, I'm sure, full plot plan.
On here?
Which plot plan are you referring to? The smaller
guy?
version, the one he has, or this one?
This guy right here.
All right.
Actually, this lot at one time was pretty much cleared. When we got it, there was nothing there. But there's a natural clearing right here. We pull in right here. There's enough room for 2 cars right here, right now, existing. Right here. This used to be a garage. Park right here. And, you know, we bike or whatever, walk, and we basically just come down this path. I have like 4 kayaks and here, chairs, walk right across the marsh, drag the kayak over,
Why not?
and then, you know, it's fine. And we
Yeah.
can still do our 10-8 float. I'll just put the 10-8 float there and be able to pull my boat up. It just would be probably a little more ecologically nice if I didn't do all that, but we have been using it for years and years, the property. And we do intend on building on the property.
May I ask a question to the
Sure.
board? What do you hope to accomplish by having this? I mean, what's it giving you that you're not getting now?
I will be able to not have to jump in my kayak, row out, and make it easier for my wife to use the boat and grandkids and all that kind of stuff. Versus, I would be able to put a ramp from here to the floating dock. That would be the goal, put a ramp from here to there.
So we're not even talking about the ramp. Yeah.
Yeah. We hear anything from Harbor Master on this? We'll get to you in a minute.
Nothing from the harbor master on that?
Yeah, we definitely need comments from him. But
Is that a buildable lot?
I don't know, I don't have enough information.
what's the square footage of the lot, do you know?
Like a little over 12,000 square feet. According to the zoning there, that should,
What is this, R3?
R3.
It's got to be 40,000 to build.
yeah, but that was pre-existing.
There's not a structure on it. If there was a structure, it'd be pre-existing.
Well,
So,
if you're going with the if I may,
Yeah.
if he's going with the argument that it's grandfather, he's got to prove it to the town.
That it had a building on it?
No, 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 no. No, that it's a grandfathered lot. He's got to show the history and all that. He hasn't provided that information at this time.
Because he's not really looking to do.
Correct. We're not there.
Right.
We're not there.
But-
But basically, it's a term where you're using, it's thrown around, but in my world, when it comes to saying whether that's a buildable lot and it doesn't meet current zoning, you have to provide proof that it does. And so there's some legal paperwork that has to be processed to prove to the town that it is a grandfathered lot. So right now, I'm just informing the board at this time, I don't have anything to substantiate the claim. I'm not saying you're wrong and all, but I can't say yes or no.
So one of the ways to substantiate a claim would be if there was an existing house.
No, if it was a
that correct?
grandfather lot, is showing proof that somebody did the research, that it wasn't held in contiguous ownership, and a bunch of other little items. You got the paperwork.
News to me.
Yeah, it's a legal thing. We had them do a title search to prove. That was held in contiguous ownership, that's all he's ever owned, it was never part of something else. Because it was part of another lot that in theory should have been the merged. It's all in Bobrowski's book, didn't you read it? It's about yay thick.
I read that you sent. It was very tiring.
Yeah, wasn't it?
No, I read that too. It's not the article he just sent.
Oh,
No,
I
but
think he's
that was
talking about
tiring
something
too.
else.
oh.
Legal mumbo jumbo. But at any rate, my job is to point out to the board that under the zoning bylaws, it's an accessory structure. And it's up to the applicant to argue it one way or the other, but we're viewing it as such. He has the right to say whether it is or isn't. But like I said, if the board does decide to grant it, I would request that a condition be placed that it doesn't get modified, added on to without coming back before the board. If you went that route.
Yeah,
I'm just giving you both sides of the coin.
gotcha.
Got it?
So if it was a grandfathered lot, and he could prove that,
What does that do with this? Nothing really.
No.
It only talks about building a house.
Right.
but if there was a house, then it would be a principal structure.
Right.
Then we could easily grant a dock.
But there is no house. I'm not planning to
So
build a
we're
house.
running in circles here.
Right.
not the dock for us,
Right.
okay? It's not, I mean, I use it, I've been using it, whether you call it a use or not, and I'll just
It's an
continue.
accessory use, a dock.
Accessory
Yeah, so I'll still park my car, I'll still take my boat out, I'll still drag my kayak across it. And,
But, you know,
Yeah.
if it's a grandfathered lot, that's something you might want to check out,
I'm,
because it makes it far more valuable.
yeah, we got that already kind of spec'd out.
Okay.
All righty?
So you want to withdraw this then?
Yes, I think that would be good.
Okay.
I think
Bill, do you want to make a
somebody,
motion?
hang on, somebody wanted to speak.
Comments?
Sure, come right up.
My name's Robert Delory.
Grab the mic if you would.
My name's Robert Delory. I got 3 Bay Road, a budding marsh in front of his property, and upland, on lot 44,
Okay.
Town Brook.
So let's take a look. All right. Do you own any land on this lot?
All right, can you show us what you're talking about,
Yes,
please?
I own this lot right here. this marsh all the way around, all the way over to here. This goes right in front, this is his piece of property right here.
Okay,
So he'd
he
have to
does not own
cross-
waterfront, he does not pay waterfront taxes.
so he needs to have access over your property
He
then?
does not, he's never even contacted me.
Oh, that's another issue.
He's also been trespassing across the marsh.
Hold on, wait a minute, hold on one sec.
Water, the marsh has changed.
Well, no, you can't.
We'll get to you in a second.
Yeah,
Marsh does not grow up on.
You got to keep talking in the microphone, or they're going to give me trouble.
All right, so, again, for the record, your name is,
Robert Richard Delory Jr.
and you own, I guess it's lot 44, it looks like 1.4 acres,
Correct.
and you own all that shoreline.
Yes, I
for the
own,
marsh line.
I own the marsh and the upland up to the property lines.
So you own the land between said property and the water, is that correct?
And, yes. And it was, the people we bought it for came out of the 1800s. It was 1850, when that marsh was owned. And when they put the development in 1919, you can see on there that my actual lot goes up into his lot. So I actually own further.
Where's your lot on here? Besides this big guy?
If you look at this line here, this comes right across.
Yeah.
Right around. His lot line goes down into my property.
So there's a question on
There's a question on
ownership.
that piece, too.
Oh,
But I definitely own the marsh in front. The marsh has not changed. It doesn't grow up on.
okay.
We just, matter of fact, there's 3 lots over, there was a dock. And we went through court on it and proved that I owned the marsh, and I gave them an easement to go across, and they put a new dock in there. I have some of the paperwork with me if you want to look at that too.
Okay.
So it's already been through court. on another-
So you
on the
gave
same
your,
parcel.
you gave your neighbor an easement to go across your land?
Right. There was a previous dock put there.
But,
And I gave it, and there was a question about it, it was only there for 20 years, and we gave them an easement on it.
That's the statute of limitations.
so it was there for 20 years before you had the discussion,
Right.
so, yeah.
Well, yeah, but we owned it right after he put the dock in. He was asked to take it off, and my father had a private agreement with him that he could leave it on till he couldn't go over 21 years on it, but both of them passed away before that.
Okay. Thank you.
County conversation?
Come right up.
He doesn't,
Grab the mic.
it doesn't own a lot. The actual shows the water line on the plan. You can see it as your marsh, as your property. And basically, most of that property line is in the water. So the marsh has changed. That plan, I'm sure, is an old plan. So basically, if he had it redone, he would see that the land has moved quite a bit. But this is my recently engineered.
Okay.
No, it's 2008.
Not that he
Yeah,
makes a difference.
This
we-
is 2008.
Yeah.
That's
Yeah,
for
we
another,
can't-
another day, another,
Yeah, that's a different department. That's between two lawyers,
Yep.
so. All right.
Okay.
We'll make a,
But it does let the board know that if you decide to come back, that's
You need
going
to
to be a
straighten that out
question that's
first.
going to have to be asked.
Yeah.
And as long as it's satisfied to the board's, curiosity on the subject, I think that'd be half your battle, but that's a biggie.
yeah, you got to show the board that in fact you own that all the way to the water.
Or have
That's pretty, I've had so
accessibility.
much engineering done over the years, and, I mean, since
You might
day one,
also-
it's been into the water, so I'm not too
I
concerned.
wonder why they come up with
Yeah.
conservation.
I don't know. All right, well, thank you.
All right, thank you.
Bill, would you like to make a motion?
sure, I make a motion on 190 Monomoskoye Road, owner Kevin Care, request for a written finding under Section 174-17 of the zoning bylaws to allow for construction of a 4-foot wide walkway, wooden stairs, and a 4-foot by 4-foot wooden platform on property located in an R3 zoning district, map 114, parcel 41A, Mashpee, Mass., withdrawn at the request of the petitioner.
I'll second. All those in favor? Aye. Thank you. Good luck.
Okay.
Papers.
Okay, we're whittling it down, John.
I know.
Okay.
Let's take a short break until the building commissioner gets back.
This goes down too, John. Marion.
There you go. These are yours, Marion. Swing inspections. Talk about paper, huh? My God.
Conservation only commented on the first of the two petitions.
Okay, Jim, would you read let's read the next two, and then we'll vote on them one by one.
The first is 171 Uncle Percy's Road. Owner Eileen B. Farrell requests a written finding under Section 174-17 of the zoning bylaws to allow the extension of 2 bedrooms on the second floor and extension of the kitchen dining area on the first floor of a single-family dwelling located in an R3 zoning district, map 117, parcel 371 in Mashpee, Massachusetts. 171 Percy Road, Uncle Percy's Road, owner Eileen Farrell requests a written finding under Section 174-33 of the zoning bylaws to determine if the extension of 2 bedrooms on the second floor and extension of the kitchen/dining area on the first floor of a single-family dwelling is set back at least 50 feet from any water or wetland as defined by Massachusetts General Law, Chapter 131, Section 40, on property located in an R3 zoning district, map 117, parcel 371 in Mashpee, Massachusetts.
Hi.
Hi, thank you. My name is Tom Bunker with BSS Design. We're representing Eileen Farrell with this project. Old property on Uncle Percy's Road. basically, we say it's non-conforming as far as setback from the wetland for the town zoning bylaws go, but I'll point out that it is in the New Seabury special permit area. And there's one question we had, I'm a little confused about what the New Seabury special permit area is for, been under the understanding that it's basically exempt from most of the zoning regulations, being in that special permit area. I'm not quite sure why we have to be here.
What happens is you're doing work within 50 feet of the wetlands.
It kicks
So
into the
once you
zone.
do that, you have to go to, do any work whatsoever. Got to go to conservation, then you have to go to the zoning board. If you weren't, yeah, if you weren't doing any work within that 50 feet, you wouldn't be here.
Well, that I understand. I had always thought
Yeah.
that 50 was a zoning bylaw, which is in your zoning regulations, which were
No,
exempt.
the only thing you're exempt from is lot coverage, setbacks. Anything more than that,
Under the special permit.
Setback from the wetland is not a
No.
setback.
setbacks from the property line, not encroaching in the flood zone or in the wetlands. That's not part of the deal. Can't be any clearer than that.
All right.
Not clear in the regulations, but you've made it clear. So we have a house here, you see from the front, on this plan. We have a sort of before and after in the upper left corner of the plan here. Existing house, and the rear, and the existing house with the additions. And the additions are going on the existing deck, except for one small corner. There's 8 square feet in this one location. So this house, the deck is within the 50-foot, I showed a 50-foot setback in that, the inset up in the corner.
Going beyond it, because you see how this is already in it.
Where the addition, actually, is one place where actually the addition is stepped back 1 foot. Basically where that diagonal corner is out of the deck. The addition is not coming any closer to the wetland than the existing deck that we have now. There's a small deck addition being added onto the side of the house, which is basically landward of that 50-foot setback, but it just touches it. But again, it is not any closer to the wetland than the existing deck is. As far as the 2 issues involved here, one is the character of the neighborhood. You see on the front, there's a little porch here, and I guess that's not in question here, because it's not within 50 feet of the wetland. This is the front view.
Right.
Adding that bit right there. In the rear view, this area, I have this is the existing deck across here in elevation. And that's here, and you see better in the plan view that's on there. But basically, this addition is taking the place of that deck. I can point out that we have another nonconformity of the shed that's way down by the wetland that's being removed.
Gotcha.
So that will eliminate that nonconformity. This has been approved by Conservation to do this work. And they've agreed, and I hope that you can agree that, they've agreed that it's not going to have any environmental damage, and this being not any closer to the wetland than the deck is now, I hope you can agree that it will have no zoning infringement. Specific questions?
Thank you. Let me read some comments. I'll start with the inspections department. 171 Uncle Percy's Road. The area is zoned R3 and is in the pre-contact archaeologically sensitive area listed as high sensitivity. The applicant is seeking a written finding under Article 5, 174-17 regarding the determination from the board if the expansion of an addition more into the 50-foot wetland buffer zone, 174-33, would increase the non-conforming nature of the home. Also, 171 Uncle Percy's Road, the area is zoned R3 and is in the pre-contact archaeological sensitivity area listed as high sensitivity, seeking a variance, 174-33, for encroaching more than 50 feet into the wetland buffer zone. So that's from inspections. Let's see, Board of Health. Okay, they're commenting on the,
Combined them.
oh, they combined them, okay. Board of Health comments. The floor plan has been reviewed and are approved for 3 bedrooms. The change in footprint requires a septic inspection. The septic inspection result was a needs further evaluation from the local approving authority. The septic tank and leaching facility were identified as being within the driveway. The septic tank is not load rated to be in the driveway subject to vehicles. The leaching facility has no access manhole cover and was not inspected. As this is an inspection for the building permit and not for property transfer, the owner has until the time the property transfer to correct the identified issues with the septic system. So the septic system is not load rated and it's under the driveway.
That's correct.
So before we can do anything, that's got to be straightened out.
Well, I think we could offer, or you could condition, put a steel plate over that to be used during construction over that tank and to protect it from any heavy loads that would be going through here.
Well, I can understand what you're suggesting as far as during time of construction. I guess the question is, what about normal everyday use? Unfortunately, the Board of Health is not here to say whether or not, their thing is that the tank, whether it's for everyday use or construction equipment, this tank is designed for it.
It's been subject to everyday use every day. You know, it's been there without failure for many years. And I can see if it might be concerned that a concrete truck could cause damage to it or something else. But I mean, it's been driven over constantly, or during the summer anyway, when we've been living there.
Well, I can't talk for the Board of Health, so.
I can just speak to what they've said. I don't think they're requiring any change now. They're only requiring a change if, in fact, the owner decides to have a property transfer. So
Right,
I'm
and that's-
assuming that they're not making this a condition of this particular.
Yeah, that's the word, that's what they've said, yes.
That's one of it. That's part of it.
That's what it says. Let me read it out loud. The leaching facility has no access manhole cover and was not inspected.
Period.
As this was an inspection for a building permit and not for property transfer, the owner has until the time of property transfer to correct the identified issues with the septic system.
But go back one sentence prior to. The septic tank is not load rated to be in the driveway subject to vehicles.
I understand. And the last sentence says,
So there's two issues.
no, the last sentence says, as this isn't, I'm reading what the inspector
No,
said.
no, no, I know you're saying.
He doesn't say you have to correct that now.
I'm not disagreeing. I'm just saying is, he made a statement here. I don't know what it means, because right now, like it says, I'm not voting on this, so I don't have a horse in the race. All I'm saying is, it says here, the septic tank is not load rated to be in the driveway subject to vehicles.
And I read that exactly the same as you.
Right. All right.
Last
so that
sentence
tells-
overrules having to do anything about the load bearing.
No, it
It has
says,
to be done to the septic unless
says no
there's a
about the
property.
inspection. As this was an inspection for a building permit.
Right,
That's what the last sentence says.
right.
Well, the inspection is one thing, but the load bearing is something different.
Is that
I'm just seeing it's two
building
different
issue or Board
But
of
once
Health?
again, I can't speak for the health agent. I wish he was here to clarify. Maybe it's poorly worded.
The way I read it is, he doesn't need to do anything unless there's a property
Hey,
transfer.
that's up to the five of you. I'm sitting here watching.
I think there are two
Any
issues.
comments?
There are two issues, okay? One issue is the integrity of the septic system, and the other issue is the load-bearing ability of the septic system. Okay? In terms of the integrity, that's fine. In terms of the load-bearing system, maybe there's something that the board wishes to do.
Well, he does
Is that
say-
clarification, or am I making it muddy?
No, I
This goes-
I agree with all of you. Unfortunately, it's, I think, poorly worded, to be honest.
In his comment, then does, in the last sentence, he does use plural of the word issues. Until the time of transfer to correctly identify issues with the system. So I think Glenn is not requiring that to be fixed.
For the work that you're trying,
For
the
the
building you're trying to erect.
Yes. Now, I mean, you could possibly find that there might be a danger here and that we should have some protection over it, such as putting a steel plate. But I think as far as the health department is concerned, I think he does use the word issues, or I think that covers all the issues that he mentioned, do not have to be corrected for the purpose of this application.
The change in the footprint requires a septic inspection. The septic inspection result was a needs further evaluation. That kind of adds something in there.
Well, that's what it is. He evaluated.
In other words, it didn't pass. I don't know if it failed, but it didn't pass.
I think it was being evaluated, I think whoever did, I didn't do the inspection, needed to be evaluated, and the issues that Glenn found were that it's not load-bearing. Septic system is not load-bearing, and that's one way. I mean, there's a requirement that, maybe not about the load-bearing, but there's a requirement that manholes be brought within 6 inches of grade. And it might be because of that they said it needs further evaluation from the approving authority, and Glenn picked up that it's not an H20 tank. But he does go on to say, or this comment goes on to say, that there's no need, the owner has until the time of property transfer to correct the identified issues, plural.
Mr.
Septic
Chairman,
system.
can I make a
Go right ahead.
recommendation that, my recommendation would be that we continue this upon the board's request for a continuance, so it doesn't go against your timeframes for continuances, until we get further clarification from the Board of Health. I agree that some of this word,
It's muddy.
it's a little bit muddy. I can interpret it the way you do, and others can interpret it a different way, and I think it compels us to get further clarification from the Board of Health. That would be my recommendation.
I agree with that. What are your thoughts, guys?
Perfectly logical, yeah.
Continue it, come back the next meeting, get it all straightened out. Honestly, I've got no issues with the plan at all.
I don't either.
Nope.
I think we do need some kind of clarifying statement from the Board of Health in order to go forward with
I think
this.
the project is fine, I got no issues
I
with it
don't either.
whatsoever.
Can make a motion, second on
Yeah. Yeah.
Say one more thing.
Let's see what he says.
Maybe they'd like to share their secrets with the board.
Tom?
No, I'm sorry, yes.
So
Well,
we think we'd like to continue it.
could I throw out an option? I mean, the main one, I don't know if,
Go ahead.
could he put a condition on it that we put in an H20 tank and bring the manholes up to grade, then it wouldn't matter what Glenn has to say.
Well, I understand what you're saying, but I also see what I'm reading, and when he says it needs further evaluation, I'm not sure what that all means, further evaluation. If you put a metal plate in, if that's going to satisfy him, that's why I really want to go back to Board of Health before we make a ruling.
Well, yeah, I'm just looking at this, the further evaluation, and I think the further evaluation came up with the 2 points that the septic tank is not load rated, and the leaching facility has no access manhole covers.
I think you're right, but I don't know.
And
I agree with you. You might be right, you probably
I
are,
really
but I
think
don't
you
know.
are right, but I think
condition that we, how about if we put a condition on that, we just meet all the requirements of the Board of Health?
Honestly, I'm not comfortable with that. I don't know about you guys.
Only thing I'd be comfortable with this right now, Tom, is to continue it until we've had further clarification from the board. That's me. I don't know about them.
Yeah, I agree.
And I understand you're trying to make as many accommodations as possible, but I'd really feel much more comfortable getting the word from him. This is what we need to see in order to feel comfortable with this. It's very ambiguous the way it's written. Not very, but it can be.
Go ahead.
Through the chair, what was the option, the type of tank you wanted to put in?
Well, the load-bearing tank, H20, it's an H20 tank, that can carry heavy truckloads.
Oh, you mean remove the existing tank and put in a new one?
His two concerns here were, as I read them, that's all he mentioned was, it's not a load-bearing tank, we put in an H20 tank, and then if it's ever sold, then that job is done. And bring on the second point, the leaching facility, bring 1 or 2 covers to grade, which is another Title V requirement.
Right.
And if we did those, or anything else, and that's all I see here, or whatever, anything else that Glenn might require as far as fixing a couple little things to satisfy it, we would agree to do those. I just don't know, reading this, what else.
What's wrong with
what
that?
else there could be.
I don't know what he means by the inspection result was a, quotes, needs further evaluation from the local approving authority. In other words, it didn't pass. I don't know what, you're making a great argument, but
Because, yeah, well,
I'm not really sure. And I'm not comfortable.
I think the further evaluation, I think you're right, not that it didn't pass, but he couldn't, the inspector probably couldn't pass it.
Because he couldn't get
Couldn't
into
see.
it.
Didn't see anything.
The
Couldn't get inside.
leaching facility has no access manhole covers and was not
Right.
inspected.
So it'd be my recommendation, like Bill's and everybody else here, that we continue this. I'd suggest go out and see Glenn right away and get this figured out. We'll go and talk with him, we'll get something else in writing, and we'll see you at the next meeting. That's my recommendation. Anybody else in the audience have any comments? Seeing none, Bill, would you like to make a motion?
Hang on.
Another comment.
Come right up.
Denise Benoit is the architect.
I'm the architect for the project, and I know you can't go by my word on this, but I mean, I have been in close contact with the builder, Tim Gray, and he's spoken with the health agent, and it was his understanding that we could go forward with it, and the owner would be upgraded if she ever went to transfer the property. That was his understanding of it, not just what Tom is saying. I know that, you can't just take my word for it. What we also thought was, because this is a 3-bedroom house and it's a 3-bedroom system, we're not adding increased flow or anything. This tank, the septic system itself is fine. It was the issue was the fact that it was over a driveway. I would say, based on my conversations with the client, that I talked with the client a little bit more than Tom, that she would, if this, at the risk of holding up the project or and wanting to satisfy everything, she would be absolutely willing to just not have the circular driveway over there. If it came to the fact that the cars were driving over that tank and the tank wasn't, if the inspector did, he's already said to the builder that it was okay to leave it until there was a transfer, but if that were to change, then all she would do was just not have the circular driveway there and just kind of put the driveway off to the side a little bit. So we felt that it was an issue that could be easily resolved. So,
Thank you.
thank you.
Unfortunately, I still feel the same way. I don't know about you guys.
Do you have any time, excuse me, may I speak?
Sure.
Do you have any time constraints? It's 2 weeks,
Well,
honestly.
it's
The answer's no. Okay,
delay.
okay.
We're trying to get it done before the summer, and so, yeah, it's huge.
Well, it's not a big project.
Yeah, it's a small.
Yeah. Bill, would you like to make a motion?
I'll read them both, and then make the same motion for both.
Yep.
Make a motion that we continue to, what's the next date, Mary Ann, that we can have this?
7th of January.
To the 27th of January. 171 Uncle Percy's Road, owner Eileen B. Farrell's request for a written finding under section 174-17 of the zoning bylaws to allow the extension of 2 bedrooms on the second floor and an extension of the kitchen/dining area on the first floor of a single-family dwelling on property located in an R3 zoning district, map 117, parcel 371, Mashpee, Mass. That's the first motion.
Okay. I'm going to second it. All those in favor? Aye.
Second motion is that I make a motion that we continue to the next scheduled zoning board hearing, 171 Uncle Percy's Road, owner Eileen B. Farrell's request for a written finding under section 174-33 of the zoning bylaws to determine if the extension of the 2 bedrooms on the second floor and the extension of the kitchen/dining area on the first floor of a single-family dwelling is set back at least 50 feet from any water or wetlands as defined by MGL Chapter 131, Section 40, on property located in an R3 zoning district, map 117, parcel 371, Mashpee, Mass.
I'll second it. All those in favor? Aye. Okay, see you in 2 weeks. Thank you.
Is that everything?
All right, Jim, would you like to read the last new hearing?
Yes. 28 Elliott Road. Owners Joseph A. and Lenora A. Skiaka, trustees, request a written finding under section 174-17 of the zoning bylaws to raise and replace a single-family dwelling on property located in an R3 zoning district, map 118, parcel 117 in Mashpee, Massachusetts.
Hi.
Good evening, Mr. Chairman, members of the board. My name is Kieran Healy. I'm a land surveyor with the BSC Group in Yarmouth. I'm here representing the owners, Mr. and Mrs. Seata, tonight. With me is Mr. Joe Calzumo, builder for the project. What we're looking to do is do a raise and replace on a single-family home. The footprint, as you can see from our sketch here, is extremely similar to the footprint of the existing house. In fact, our lot coverage is going from 18.9 to 19.9. 20% difference. We're still under the 20% maximum allowed by the town. We're here filing under 174.7 finding fact. The property, the primary reason I believe that we're here is because the current building is less than the existing setback minimum requirement to the street. We're looking to hold that existing building setback, so it will be less than the minimum requirement that is allowed by the town. You can see here on the plan, we've got 21.9 to the existing building and 21.9 to the proposed building. The street setback for this Papaneset overlay district is 25 feet. So we're matching what exists, but we are less than the proposed, than the current zoning for the area. It's a three-bedroom home, it's existing, and we're proposing a three-bedroom home. As I say, the only few changes are right in this area right here, which is further away from the street and still conforms to the street setback.
Do you have plot plans for us?
I got house plans. I don't see a plot plan. though.
These little ones,
Do you get one? Where is it? Hidden?
Someone hanged on to it.
you want this one?
Here we go.
Would you like this one?
Right now I do.
Oh, you gotta, where'd you get that little one?
They just got handed back to me.
You got another one?
Probably in the middle of the...
There we go. Thank you. Sorry.
Well, we've got 3 pages on those plot plans right there. The first one is purely just the zoning information, all the information about setbacks, existing and proposed, lot coverage, ownership, all of those pieces of information. The second sheet then shows the setbacks and the house itself. The third sheet shows an area down near the water, which is where we're proposing a patio. On this particular project, we have been to the Conservation Commission, and they have issued a order of conditions on the project. We have also submitted plans for a septic system to Mr. Harrington, the Board of Health agent, and he has also approved the plans as we've got them proposed.
Ask them about that.
So on the south side setback, you're going, allowed is 15, but you're going from 28 to 30?
Correct, yes, and the reason for that is this is the water side. From a conservation point of view, we were trying to pull it back a little bit as well. So basically, it's increased from the original setback here of 28 to the new setback of 20 feet to the deck.
Yeah, it's just,
We're increasing from the existing 28 to the proposed 30 feet to the deck corner.
So it's a reduction in the,
If I could just go through the corners. As I was talking about the street setback, we're matching. It's 21.9 existing, 21.9 proposed.
Correct.
On the north side, the setback is 15. We're existing at 22 and we're proposing 20, so we're still 5 feet greater than the minimum allowed in that area. On the rear, we're coming right to the 15-foot setback. Right now, currently, we're at 16, and we're going to the 15.1 on that rear line. And then on the south side, near the ocean, we're increasing the setback from the 28 to the 30 feet. The deck falls over, is in this area right here, that falls over the walkout patio that's on the bottom level. So from a setback point of view, the only place where we don't conform is the street side, where we're matching the existing setback.
This is as you know, I don't have the authority to grant.
Say it again?
Which you know I don't have the authority to grant. Hey, every opportunity I can get. Let's try to make a point.
Thank you.
Thank you.
Point well taken.
You're going to have dry wells on this?
We hadn't proposed dry wells, but we can, if that's something that the zoning board, generally it's the Conservation Commission that we deal with when it comes to the dry wells.
That whole, yeah, that whole area tends to flood down there.
And I'm sure my client will have no problem with dry wells.
Yeah, so
Now,
that's
we are
one thing I'd
proposing-
like to
I'm
see.
sorry, Mr. Chairman. We are proposing a large dry well right here at the walkout level, this darker green area, which is going to pick up anything that might run off and back towards the low area out here. So we are proposing a large one in the rear already. We could propose a couple of smaller ones on this north side right here, away from the ocean.
Well, the issues of the streets, and
Okay.
I'm not sure this street is the major problem, but the streets down there that flood every single winter. I mean, stuff you could put a rowboat in right in the middle of the road.
Right. We happen to be, in this particular case, we happen to be right at the crest of the hill. You actually drive up Elliott Road.
Yeah,
It's
but we
lower
all,
back-
yeah, so it wouldn't affect you, but the water might affect somebody else.
Yeah, we'd have no problem putting in a dry well right here, picking up this side, and putting a dry well on the back side, picking up
Okay.
the runoff in that area.
That's what I'd like to see. Other than that, I don't have any issues.
So one would be on the north side,
One would be on the north side, where I've got labeled Test Pit 2 on the
and
plan.
the other on,
The other would be on the south side, about 15 feet south of the septic tank.
So that would cover everything coming off the roof, those two?
That would cover all the front half, and then this big one in the back would pick up the back half, the one we've already proposed.
Good. See if there's any comments. Okay, we have something from Conservation. Conservation approved this project on the December 10th meeting. No issues. The work may proceed upon verification that the order of conditions has been recorded at the Registry of Deeds, and a pre-work on-site has been scheduled with the agent.
And as you discussed earlier, Mr. Chairman, that basically means that the agent is going to meet the builder on site to be sure all the controls are in place so that the mud doesn't wash into the ocean.
Okay, this is from the Inspections Department. 28 Elliott Road, the area is zoned R3 and is in the Pompanesett Overlay District, also in the pre-contact archaeologically sensitive area listed as moderate sensitivity. So if you're digging and you find anything, stop and call the building department and let them know.
That's up to you.
The applicant is seeking a written finding under Article 5, 174-17, regarding a determination from the board if the removal of the existing home and replacing it with a new single-family home would increase the non-conforming nature of the home. Okay, Board of Health. Proposed floor plans have been reviewed and are acceptable for 3 bedrooms. Septic tank is proposed to be replaced with a variance that still makes the septic in more compliance than before. The leaching facility is to be inspected prior to building permit issue. Demolition checklist will be required to be completed and submitted prior to demo permit issuance. That's all we have. Any comments, questions from the board? Anybody in the audience? Seeing none, Bill, would you like to make a motion?
Okay. Make a motion to approve 28 Elliott Road owners Joseph A. and Lenora A. Sciazza, trustees' request for a written finding under section 174-17 of the zoning bylaws to raise and replace a single-family dwelling on property located in an R3 zoning district, map 118, parcel 117, Mashpee, Mass. And it is conditioned on the following. The board has determined that the applicant meets all the conditions of a written finding under Mass General Law 40A, Section 6. It is also conditioned on a plan of land to accompany a finding of fact application at 28 Elliott Road, Mashpee, Mass. Prepared for Lee and Joe Sciazza, 11
Osceola?
Osceola
That's all right?
Path,
Osceola.
Path, Arlington, Mass. 02474. Oh, man, some good names here. I'm not going to read that. BSC Group, 349 Route 28, West Yarmouth, Mass. Scale 1 inch equals 10 feet. Date 12/10/2015. File P:/. No, I'm not going to read all of that.
As noted.
That's enough. Job number 49957. And also conditioned on Sciazza House, 28 Elliott Road, Mashpee, Mass. DDB Denise D'Ambrosi, Bonoli, AIA, P.O. Box 991, 469 Acapesket Road, East Falmouth, Mass. 02536. First floor plan equals 1/4 inch equals 1 foot 0 inches. Second floor plan 1/4 inch equals 1 foot 0 inches. Lower level plan 1/4 inch equals 1 foot. Elliott Road elevation, side elevation, water side elevation, driveway side elevation. It's also conditioned on the installation of 2 dry wells, one on the north side of the property and the other on the south side, and also conditioned on the comments read in previously by the chairman relative to the Board of Health and the Conservation Commission,
And inspections.
and inspections.
Weren't there 3 dry wells, 1, 2, and then 3?
He's already had 2, one of them on there and the other
So
2.
you're adding 2, is that correct?
2, yes.
I beg your pardon.
One in the back and one in the front.
Right.
They'll catch all the runoff from the roof. Okay, I think we covered everything. I'll second it. All those in favor?
Aye.
Aye. All those opposed? Okay, the ayes have it.
Thank you, Mr. Chairman. Thank you, members.
Thank you. Nice project.
Paperwork. Oh, man.
Oh, wait. Come on. Oh, this is coming back.
Taking the shade, you figure it out on our
Thank
side.
you. It's 2 of them, right?
Yeah.
No, I mean, I stamped 2.
It's the 13th?
Yes, it is.
It's the first time I've written 16 this year.
Do we have a second one of these? Signature pages? Oh, there was just one. You're right.
You're thinking of the last one.
Sorry.
Those are the extras.
It's the first time I've written 16 this year.
There you go.
There's another stamp.
I have to use the rest.
Go.
Okay.
All right, we'll take a short break while Bill is out of
Taking
the
a break.
office.
Hold it, you're done with these, right? Yes. It's an extra.
Good, that's good.
Paperwork?
I think that's it.
You'll excuse me for a few minutes?
Go for it. Hurry back.
I don't know what this one is. Yeah. Okay, just before.
Whoa. I didn't see Joe Cole sign it, did you? I didn't notice him. I was with him this morning. That's who I was meeting with this afternoon, I mean.
Planning? Okay, that was a good guess. Was he a planning,
people
board of
do,
health,
that's what I said.
conservation, somebody?
Yes, buddy lives across the street.
Mike.
Wilson. Mike, we gotta get a clarification.
Right, oh, that reminds me. I was giving her my notes. I was going to ask tomorrow when I see him.
Yeah.
What the hell he's talking about. You want me to ask him just to send you all a letter? Or just to send it to Mary Ann?
Either one.
Okay.
As long as you understand and then we understand.
Yeah.
Something in writing we can read.
But the thing is, like, what I don't know is, I don't know, like, does an H-20 tank do the job? I don't know.
Likewise. All right. All right, Jim, would you read the first other business?
58 Echo Road, Lou and Ann Seminara, to address minor modifications to existing permit.
Hi.
I'm Lou Seminaris, my wife Ann, and I believe we're looking, we didn't get the top coat on the asphalt, so,
If you would explain to the board exactly why you're here, what were the issues?
okay, the issues,
If I may?
yeah,
Jump
just,
right in.
I'm not, there were so many issues, I'm not sure where to start.
I'm gonna cut to the chase here. When the board approved this project, they didn't give me any leeway, one way or the other, regarding if they couldn't finish a portion of the project. I don't have the say. I have to follow the approval process in this case. The parking area doesn't have the final coat, it's not being striped, any of that sort of deal. So because it's outside of my ability to grant it, it's gonna come back before the board to say, look, whether or not you feel I can grant a temporary certificate of occupancy. And what this does open up, believe it or not, is in the future, when a project like this comes before the board, I'm gonna be requesting that there's some type of leeway granted, or in this case, because of the fact they couldn't complete the driveway, they actually posted a bond, if I remember correctly.
Yeah, we gave you a contract number for the work to be done by the fellow that did the base coat, and we gave you a check for around $20,000, which you have.
Right.
Which,
Do we have copies of that? You could pass to the board? Good.
in your folders. So that's part of the problem, because there was no wiggle room for me, it's gonna come back here before. So basically, and I'm not representing the applicant, I'm just trying to help both parties out at this point. They're getting to the, close to the point where they can request a temporary certificate of occupancy, but because of the way the conditions were placed on this, it didn't give me the ability on a partial project.
Everybody understand that?
So what are you looking for?
So they want to move in, but it's not finished.
Give me the
They
authority.
can't put the coat down because of the cold weather.
Right.
So if he puts up a bond saying he'll do it,
Mike can issue a,
certificate of
Temporary,
occupancy.
right.
That's what this is about.
That's the
Here's the
abbreviated
paperwork
version.
that goes with it.
yeah.
Copy of the check and the
I
bond.
appreciate that help.
problem.
I didn't know where to start.
Well, I didn't want to get into more of the technical aspects of it, but
Want me to
really
pass
to
this
focus
Yeah, if you guys
on-
want to take a peek at the
Site
stuff,
issue.
this is the paperwork that
Which
they
they-
submitted.
It's gonna be 55 degrees, weather and all
Yeah,
that.
right.
Right.
So it's too late to put the top coat down. It's got all the information, including a copy of the check that is on file, so.
So what we're doing here tonight then is to grant
A minor modification.
minor modification so that they can get a temporary
Certificate of occupancy.
CO. Right.
Would you like to make a,
I'll make a motion that we grant 56 Echo Road.
58.
58.
58, sorry, jeez, I
Another
don't want, I know it is. 58 Echo Road, Lou and Ann Seminara,
minor modification?
a minor modification to allow the building inspector to issue a temporary certificate of occupancy.
For an existing permit. I'll second that. All those in favor? Aye. Sounds good.
Thank you.
Thank you.
Good night.
Right.
Give me 10 minutes after I open the door to be shown up, okay?
Okay, nothing to sign, correct?
No? Sure thing.
Absolutely.
You just want me
You
to
better
work.
staple it together so it doesn't go,
You're not helping.
because if it, we're just stamping the top copy. You know what I mean? Easy for you to say.
Yeah.
All right.
It's just like being at home.
You think?
Oh, yeah.
No way, tomorrow, see, works for me.
You know what? I'll just sign them anyway.
So we'll still staple them together.
Can I have, once they complete that, does the check get released back to them?
Yes, if everything's completed, right, that's all.
What's,
No
who,
different than
who,
153.
who's the authority to get them back their check? You?
Yes and no, it'd be myself, and I'll be talking with Charlie Raleigh.
Yeah.
Because last week I had how do you think I felt when she went, I pulled all the parties together to have a conversation, and Charlie Raleigh was there, and we just addressed a bunch of issues. So, like the applicant was saying, didn't know where to begin. Well, I just wanted to focus on what, overall, what the issue was.
How am I doing?
Better than me.
Does this go back to Mary Ann too?
What's that?
Your right hand is turning blue.
Yeah, have that.
All right, we're all set.
Okay.
All right.
Writer's cramp?
Yes.
There
Jim,
you
would
go.
you read the
65 Secundit Point Road.
Yeah, next, other business, thank you.
Attorney,
Oh, we still got more.
We got
One
a
after
couple
you.
more after you.
Go ahead if you would, Jim.
65 Secundit Point Road. Attorney Brian Wall requests an informal discussion for clarification of variance 2013-62 and variance 2013-63.
Hi.
Good evening, through the chair. My name is Brian Wall. I'm an attorney. I have an office in Sandwich. And I'm here tonight representing Brown and Catherine Lingenfelter, who are the owners of 56 Secundit Road. I asked through Mary Ann, your administrator, to be put on an informal basis to seek some clarification as to whether additional relief in the form of a minor modification is needed, or, as I hope you might decide, not needed. If I could just give you a little bit of background, but take about 2 minutes. My clients own a piece of property on Secundit Point Road. It's about halfway down the peninsula. It was a lot created in 1928. It's 1.24 acres in size. It extends entirely across the peninsula. So one border of the land is Wacoya Bay, and on the other side is Little River East. And Secundit Point Road actually goes through the property to serve properties further down the peninsula. At the time that I appeared before you requesting relief, the property was improved by a small two-bedroom, basically a cottage, and a detached garage. And what the Lingenfelters wanted to do was they wanted to add on to the dwelling, which was subject to a special permit because it was too close to the wetlands and I think the side setback. That's not part of tonight. The other part of the project was they wanted to build a boathouse in order to create some storage space and some additional living space up above. That structure required 2 variances. One was from the setback to wetlands, because essentially on the peninsula, there were wetlands on both sides, and when the 50 feet was laid out on a plan, there was nowhere a structure could be built without a variance. Another variance that was requested was under section 17431 of your bylaw. You have a requirement that buildings must be no further than, or I should say, no further than 150 feet from a road that is suitable for fire equipment. And I don't know if you're familiar with Secundit Point Road, but it's a cart path that is not suitable for a fire truck. So we appeared before the board and made our presentation, and the board granted the requested variances. The variances refer to a site plan which specifies exactly where the structure is supposed to be, and the structure is exactly where it is supposed to be. The variances do not refer to any elevations or designs of the structure. Now, and I should also say I reviewed the minutes of the board meeting, and they're also silent about any elevations or design considerations. But I can tell you from my memory, about 2 years ago, what I think happened. During the course of the hearing, the board was concerned with where the floodplain was, and the board wanted to make sure that the living space in the building was going to be elevated above the floodplain.
You're talking about the
boathouse.
little house or the boathouse?
The boathouse, the new
Okay.
structure. The existing structure did not have to comply because there was an issue with that. We had to demonstrate that we were not making more alterations. There was a question of the value of the alteration.
50%.
Yes, and we remained under that. What I'm here for tonight pertains solely to the boathouse.
Okay.
And so and the reason why I say it's from my memory is because I looked at the minutes and they're silent, and as I said, the permit themselves do not refer to elevations, it only refers to a site plan. But what I recall happening, and I did look at my file obviously too, is that the board had some concerns that the proposed habitable space in the new boathouse would be above the floodplain. And so the board asked us to submit some elevations to show the board conceptually what was being proposed, and we did. And I have copies. I didn't want to overwhelm everyone because I know it's not on your agenda. Here are, I should say not on your agenda, not a formal public hearing, but here are copies of the variances, the variances that are at issue, and the plans that I'm gonna refer to.
Thank you.
So if you go into the package, there's a letter that I actually sent in to the board back in January of 2014 that had a number of letters of support from the neighbors. This is what it looks like. And the last page of that letter, last couple pages, had some floor plans. And if you look at the bottom of the very last page, there's some elevations of what the structure,
Number 7, boathouse elevations.
it's actually, yes, that's correct.
So we're gonna,
Mr. Liberty. It's actually the very last page of that package is what's relevant.
Okay.
And so, because my clients at that particular time did not know whether or not the board would see fit to grant the variances that were being requested, they didn't have building plans, but they asked their architect to prepare a schematic to show the board. And you can see on the bottom, it shows the boathouse, what it was going to look like. But also what's most prominent on the plan is the sidewall and the living space. And the board was concerned to make sure that the building living space was going to be elevated above the 100-year floodplain, and that there would be blowout panels on the first floor so that in the event of a storm, a dramatic storm, the FEMA code was complied with.
right.
So having given that to the board, as I said, saw fit to grant the requested variances. And again, when the variances were granted, and you have them in front of you, and I'm just going to refer to, it doesn't really matter because they both refer to the same plan. But if you go to, for example, in number 62, 2013-62, when you get to the conclusion section, I won't read it all, but basically it talks about granting the permit, and then it says referencing a proposed site plan prepared by Cape and Islands Engineering, which I saw that you had that up there. And again, there's no question this structure is being built in accordance with that site plan. There's no doubt about that. But what has happened is that as the construction, which is now currently underway, the building is up, and as I understand what I think happened, because it's all second person to me, is that in the course of conducting one of the usual inspections that goes along with construction, the building department noticed that there were some changes from the plan that you have before you with what's going up. And essentially, the changes have to do with window placement, dormers, and essentially cosmetic issues with regard to the exterior of the building. And they're part, I gave you, these are the plans of what is actually being constructed. And so, and they're part of what I gave you.
Is the footprint changing?
No, not 1 inch. The footprint is exactly the same. The height is exactly the same. The width and length of it are exactly the same. The differences have to do with essentially the dormers and the window placement is where the changes have been made. And if the building inspector wants to correct me, because again, this is all secondhand, it's from what I've learned.
You want to jump in?
Well, basically, what's this, if we recall, in the past, we had an applicant who had a special permit, and they had to come in because they made a change on a dormer. Scott. That's a little project. We had it because it was approved for one look, and then he was making a change, and he had to come back before the board. So we've already, this board's already done that, addressed this. The second thing is, if I recall correctly, and the secretary will confirm one way or another, in the pile, I'm sorry, I'm tired. In the original folder, there is a plan that was submitted. It basically was marked off by
Was it
an
signed
abutter
off?
that was signed off saying that, one of the abutters saying, we approve what was been shown to us.
Right.
Now, I just love doing this part, so I know you love this, Bill. So like going to the point about the written finding, the reason why the board has the authority to make the determination whether or not the change is more non-conforming or not is because, as has been pointed out to me, is that if an abutter felt that's not what they had envisioned, gives them a right to come here before the board. So I guess what I'm saying is, because we've got a plan on file that was signed up by a abutter saying, we saw this plan, yep, we're happy with it, and that's what we're giving our blessing to the board. So if you've got that in that packet, now we get something slightly different. And like I said, we've done this once before. Scott's project came in because he made changes on the dormer. You know, you've done it before, so it's a minor modification, but the board has to grant it. And that's my position, because like I
I
said,
think what we'd have to do is grant it, if we do choose to do that.
Correct.
And sign off on the new plan. To
You
show-
could do a minor modification, couldn't you?
But I mean, wouldn't you want to have
Address
on
the
file
fact.
what it's actually going to look like versus what we agreed it was going to look like?
what was presented, because like I said,
As
we've got a
as it was
plan
presented.
from an abutter who signed off saying, yes, we're happy with this. And that's always been the board's concern, that somebody comes back, knock on my door saying, this is not what you approved back in whatever this was, 2013 or whatever.
Okay, I have a question. Where's the stuff that was approved? Do we have a copy of that? That, I wasn't there, Bill signed
It
it.
references it all.
Bill's fault, yeah,
If you,
Bill's fault.
Bill's fault.
No.
My fault.
There was obviously a plan, a picture of what you were going to build that was signed off.
There was a site plan that was submitted, yes, exactly. And as part of as part of the petition that we filed, what we did was we gave, and I did not bring a copy of this, but we gave not a plan, but kind of a 3D things that architects prepare
Sure.
on their computers, and it was in color. I apologize for the black and white matter, but what happened.
So we have this approved downstairs,
Well-
all signed off, Mary Ann?
we would have to.
Well, we don't always
No, I don't recall
approve
seeing anything
house
like that.
plans.
Yeah, if I could interrupt just for 1 minute, because I think that, and I don't think there's any problem with the changes complying with zoning, that this, what's before you is a question of, do we need to come for a minor modification or don't we? So and what I mean by that too is that I'm not trying to evade your review, but the issue is that the building is under construction, and because of this question, there's been a stop work order put on this until this is resolved. So I would prefer, and I'd like to be heard on whether or not, did I misstate that?
Yeah, I'm not aware of a stop work order, so yeah, you've got me already.
My-
That's a biggie in my world.
Let me rephrase. I've been told by my client, and more specifically the builder, that they should stop work until this is resolved, and work has stopped.
Well, that wasn't from me,
Okay,
so I'm assuming I have to talk with the local, but I'm not aware that that is what has transpired.
okay.
All I can tell you, as far as my knowledge of this, is, like I said, there's been a minor change, and the fact that we've got a plan on file of the from the ZBA.
Yes.
You know, sign up with a butter saying, we like the look.
Right.
And that's what's written on there. Other than that, I'm not aware of any stop work order, because it has to be official paperwork done, and there's nothing, so maybe,
Maybe I overstated it, but my client told me that there's a problem and that they've been told to get it straightened out, and that's why we're here.
okay, maybe that's true, but
Sure.
stop work is a biggie.
Okay.
Okay.
I'll withdraw the comment.
Is that who signed off?
But what I'd like to get at is this word about approved, because I think the building inspector has, commissioner or inspector?
Commissioner.
The building commissioner has stated it exactly correctly, is that the issue, as I understand that your department has, is that there's this plan, there's a letter from an abutter that refers to a plan. But what I'm submitting to you is that the architectural plans were never approved by the board. The request for relief relates only to dimensional variances, the dimension of the 50-foot setback to the wetlands and the 150-foot to the road. That was what was before the board. We were cooperative and helpful, and we provided this rendering, and then when we were asked about the floodplain elevations, we cooperated and gave those to the board.
This is what was presented.
That was part of the petition, yes.
So is this in here signed off that we approved this? Because if it's not,
It's not. Well, I would defer to the review, but it was information supplied to help the board make the decision. The request,
Had it at the time.
yeah, but there wasn't approval.
Assume, I can't remember 2 years.
And if I could say.
help me out here, correct me if I'm wrong. You presented this, but it's not signed off
Right.
as being, this is what you guys are gonna build, and it's not in the folder, then we don't have to hold you to this.
That's right. And that's what I'm trying to say, is that what the board approved,
Do you understand what I'm saying?
I do. I see what we've referred to in the decision, and it's not the architectural plan. It's the plot plan.
that is correct. And let me just by contrast, if this were a special permit, like the cottage was, the test would be whether what was proposed is not substantially more detrimental to the neighborhood than the existing structure. And then I would clearly agree that whatever was presented was approved, and any change to that would require relief.
I agree with you.
Yeah, all we got relief from was, I shouldn't say all, it was significant relief, but it was the dimensions. It was the 50-foot to the wetlands, and
Right.
it was the road. And that site plan was approved, it was signed off and approved, officially approved, and it is incorporated into the variance, and we are in compliance with that.
Right.
We provided information to the board to help the board make its decision by showing a graphic picture. There were no building plans, because again, the variance, we didn't know if you were gonna give it or not, and so they didn't have building plans, but they had a good idea of what they were gonna build.
I agree.
And then we gave you those elevations because the board said, we want to make sure the living space is above the floodplain.
Right.
Ask for a continuance, come back, and make sure the blowout panels are shown, and we did that. And the structure, as you can see, it is substantially the same as what's being built, and like I said, the height is the same, the width, the length, and the location is in complete conformance with the site plan. There hasn't been 1 inch of deviation from the site plan. The issue is that they took a little liberty with some windows and doors and moved them around. And again, I defer to the building department was correct to say, wait a minute, we're not sure about that. But I would respectfully submit that the information that we supplied to help the board make its decision didn't actually end up in the permit, and since it wasn't approved, we don't need to get a modification to change a facade.
I agree.
But what about the fact that you got a plan on file that's signed off by one of the abutters saying, we approve?
Where's that plan?
I think that
Was it signed by the board?
No.
No, it was by the abutters saying that we saw this, we approve of this.
Yeah,
It
but
was
he's
part
not
of-
on the board, is he?
You're not listening to me.
He's
They
running-
submitted it as saying, hey, we saw this as a abutter, I don't have a problem. Because I'm going back to what you always say. Well, if a neighbor says, hey, I was at that hearing, that's not what we saw, I got a problem.
Honestly, I don't have a problem.
I don't either.
Okay, I'm just saying.
Either, yeah.
If we had signed something off,
I'm done.
if we had signed that off and said, you're gonna build that,
Yeah.
and you changed it, that's different.
I'd be coming from.
But I
another
can't hold you to anything because I didn't sign anything. I wasn't even
Then why
here.
did you do it for Scott?
Honestly, I wasn't, I don't know if we signed off on that. If we signed off on a plan saying you gotta build this,
We've got a package of what was.
changed, that's different.
We've got a package of what was approved. What was approved in that hearing was the plot plan, or whatever you want to call it, showing the dimensional. You may have shown us a rendering of something that you thought you might build going forward, just to make us feel good about what was going up. That was never incorporated as any of the package that was approved.
I agree.
Then why is the plan in her file?
I don't know who signed it. I didn't.
if it's
So
the
you
other.
accepted, if an abutter was here right now and signed off saying, we have no problem with this, you would accept it into the record, would you not?
His comments, absolutely.
Well,
Is
isn't
that
that part
here?
of the record? You have it.
Is it there? I'd be happy to look.
I don't know what it is. Is it signed by the board?
No. It was
It's
submitted
not
as
part of the record. It can't be part of the record if it's not signed off by the board and stamped.
Unless maybe it was read into the record.
It definitely was submitted as part of the process, but, you know, so if you look at my application, I also had deeds, and I was showing you an easement about the road. I mean, there was lots of information that we submitted, and I'm not trying to harm the abutter in any way. My clients went out and contacted all the abutters, and that's why we submitted, I was the one that submitted the letter from the abutter that said, we have no problem with this project.
This is provided right now.
The answer is, never give information that isn't requested.
You know, you gotta walk a mile in my shoes, because my approach to the boards is to.
So this is 2 years old.
Yes.
This is in the file.
And
Should it have been signed off? Probably.
I don't think it should have been, because again, the relief being requested was only for dimensions. If this were a special permit, and we said that this is
Well,
what
I
we're
need to
gonna
know what to
build.
do on my end, because right now, I'm getting mixed messages
From who?
from the board, and I'm a little annoyed right now.
What mixed messages are you getting, Mike, that annoys you so much?
Well, first of all, we do it one where, this is the way it looks, we brought one applicant in, had him go through the process. Here I've got another, we're not gonna do it? I don't understand. I'm consistent. I treat everybody the same way. So it's
I
like,
think we do too. Go on.
I'm not saying it. And that's why I'm finding it because it's hard for us to do it, because the first thing we do when we have somebody comes in, it's going to the Board of Appeals. And unfortunately, I feel for you right now, believe me. And then we get a question, we pull a file, says, what does the file have? What was submitted to the board? Does the shape look the same? Is the floor plan the same? If it's not, well, this is not what the board reviewed. Whether it's stamped or not, it's in that file. It's in that file.
Okay, I
can't-
understand what you're
can't-
saying is in the file, Mike. What was approved and stamped by the board?
Yeah, but how do I know the board didn't start stamping things? I've only been here for a year and a half. You could have started this a year, a year, 1 month.
Was the plot plan in the file and stamped?
That's it, yeah.
That's it.
Right here. This is it.
That's what you can go by.
And if
Whatever was filed, signed, and stamped.
I understand your point, and I agree with you.
Then that
And
should
it
be in there.
It should have been stamped.
Or it shouldn't be in there at all.
And actually, could I give you the perspective of the property owner?
Okay.
Sure.
So for example, when the client called me up and said, there's an issue, and so what's approved by the board goes both ways, so that everyone knows where they stand. And so I looked at the permit, and I said, well, when the board approved it, they approved the site plan. And if it said, and architectural elevations, then we would all know that that's part of the permit, but that's not part of the permit. And in fact, in this case, it never was intended to be, because if the board were going to stamp that plan, I would have asked for a further continuance, because it was just a conceptual plan to show an idea at the time. So in other words, my point is that we all know what the permit says. If it's a document in the file, that doesn't necessarily mean it's part of the permit. I submitted an application with deeds and all kinds of information, but the permit is the relief from the distances.
But it's part of the packet that was submitted, that was accepted by the board because it's still in their file. That's what I have for
It's
reference
not part of the
material.
permit. What we're here is, let's take it a step further. If I'm asked to modify the permit, if I'm told the consensus of the board is we want you to come by for a minor modification, what am I going to modify? And I'm not being facetious, but the permit refers to the site plan. We're not changing the site plan. The site plan is the site plan. We're changing an elevation, a window in a dormer, and that wasn't part of the permit.
Well, I'm just saying this board has required a modification because somebody did change a dormer.
And again,
That's probably because the original dormer was signed off, I
And-
would hope.
and I think that would be the case, that if the architectural plans were part of the permit, there's no doubt.
I understand where you're coming from, Mike, and I agree with you. But I think there was maybe some miscommunication here. Maybe it should have been signed off.
But there's also a difference between, and I think I have the consensus of the board, so I should probably stop talking, but my point is that there's a special permits and variances are different.
Right.
Special permits are substantially more detrimental, so everything matters. And if we change a window or a dormer on a special permit, you got to get a minor modification.
I like to disagree respectfully, because today myself and that gentleman over there sat in on a training put on by an attorney who would say it all matters, whether it's a special permit or a variance. It all has impact about change.
Can we cover everyone then by just issuing a letter under the auspices of the board saying that you can put another dormer on? Because
That's not the question here.
I know it's not the question, but that's what he's looking for.
Is it- Okay, is there, well, let's cut to the chase. How do we make this go away?
Yeah, that's what
No,
I'm
I
trying to
mean,
do.
I'm just explaining my point
Honestly.
of view, because my office is getting mixed messages, because no matter what happens, we're gonna go in that
What would you like to
file.
see happen then?
Not me. No, my thing is this, if I go into the file, when anything has gone before the board, we take a look, and we match up whatever's been submitted. It's part of the record. As far as we're concerned, it's in that file. Whether it's stamped or not, it's part of the file. So, as far as I'm concerned, if the board wants to tell this gentleman he's good, have a great night, I'm good. I really am. But I'm gonna have a problem in the future as far as the next project I get, I open up the file and I see something, now I don't know, because I don't wanna waste another person's time to come here because whether they put one dormer on or 20, and I'm finding the file, and it's a question whether or not it's stamped or not. As long as I see it in that folder, it's fair game. Because I wasn't here. I had to presume, and then counsel can say the same thing, if he was on the other side of the coin, but it's in there. I can't dismiss it.
I understand that, but I think as they say, the horse has already left the barn. It's already been written. This is what was stamped. And I understand where you're coming from, and I agree. You should be able to go there and say, this is what you guys are gonna build. But it's already happened. It's already by. That's just my opinion.
My opinion is whatever's in the folder, if it's not stamped, it doesn't belong in the folder.
Hear that?
Have there been some errors? Probably.
Yeah, I'm sure. But if
So the
it's-
easy way is, how do we correct it? So, number one, it doesn't happen again, and we can kind of make it go away, because I don't think it's a big thing, to be honest.
I don't either, but I can also state, if something gets misfiled in a folder and you look at that and you say, well, that's in the folder, doesn't even belong there, it's not stamped, it's not signed off by anybody, anything could be in a folder. If it's not signed off and stamped, it's not an official piece of,
Well, we don't have,
tend to
what
doubt
happens
that
is
it's
we
a
don't have a
court of
leg to
law,
stand on,
and
do
it-
we?
Well, I wouldn't put it that way, but, because I'm here.
But you understand what I'm saying?
I do.
The way it's written
I
there.
think there's an easy way to solve all those problems is, the way that the board already is writing the permits is that, in this case, the board knew it was granting dimensional variances and referred to the site plan. And again, without being facetious, so just by illustrating the example, if we change a dormer and it doesn't have any effect on the distance to wetlands or the distance to the road, it has no effect on the relief that was granted. In cases of special permits, or even if, in this case, if the board felt they wanted to have that plan, they could have said, it says referencing a proposed site plan, blah, 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 and it says also septic system, and it could have said, and the elevations provided by the client, and then the elevations then become part of the permit. And I would completely agree with the building commissioner. Any change, any deviation from an approved plan requires
right,
a
I
hearing.
agree with you.
But in this case, it was dimensional relief. That hasn't changed. And the plans were submitted to give everyone an idea of what was being built. And it is substantially the same. I mean, it's not like we've come in with a different project. It's, the windows have been moved around a little bit.
All right. Well, we beat this thing to death, I think. What are you asking us for here?
I'm asking for
Let's see.
some clarification, so a vote or consensus of the board that says that a change of the facade does not require modification to the variance.
In this particular case, I'm going to agree with you.
Okay.
I don't know if we have to make a motion on this or what. It's not a formal, it's an informal.
It's informal.
So that's my position. What's your
Same.
position?
I agree.
I agree.
I agree. Does that make you comfortable, Mike?
No comment.
Well, you know what, I think in the future, we need to probably cross our Ts and dot our Is a little bit better, and I understand where you're coming
I
from.
want Mike to be comfortable with whatever we do, so that there's something he can always come and say, you know, I did this, and this is what I'm supposed to do.
I understand that. I think we're in a position, though, where,
Yeah.
The only thing I want on this, I want it part of the record, because if I get that individual with the original plan knocking on my door, I want to be able to show I tried.
Sure.
The board did said something, and this is what they did. That way, my hands are clean.
Well, the board does have certain discretionary powers.
I understand that, but once again,
We'll write it down for you. Is that,
it's in the record.
well, just make sure that all this is in the minutes. And we'll go from there. So I'm fine.
Thank you. I
I
appreciate,
think everybody's fine.
appreciate everyone's time.
Thank you. All right. Here's the original. It's coming back. That's an
Set it
original.
all down.
Have a good night, thank you.
Have a good one.
Oh, well, we got some more.
You got one more.
You get more?
No, don't we have more of these? I only got one, I thought. These plans,
Yeah.
Are there more? Here we go.
There we go.
Thanks.
Oh, look. Oh, look at this.
Now, we want to give them to you.
All right. Let's see, Jim, would you read the last other business?
153 Commercial Street, signature required on voucher to return deposit balance to Cape Wide Enterprise.
Everybody?
Yeah, we just need signatures, Cape Wide, basically, the project's
take mine?
completed. This was even before I started, and they're satisfied. Charlie Rowley gave us.
Department head, that's you, isn't it?
Hey, me.
Charlie Rowley said that it's done?
Yep.
Okay.
Need a date here?
Yes, 13th.
Mary Ann, being new, who's Charlie Rowley?
Oh, he is an engineer that the town hired. He's an outside consultant, and the board had hired him to look at this project.
Okay, thank you.
Yeah, the town doesn't have a
Engineer.
town engineer. So when we have projects, like commercial projects like 58 Echo.
What is it, 13th?
Yes, 13/16. We hire them to come in, do the work that the town engineer would do, and the applicant pays that bill.
Okay, I just,
Yep.
like to be brought up to speed.
I understand. Good question.
Scott's next.
Yeah, I know.
And the last one?
We'll just wait. Don't take this folder home. Get in big trouble. I know. All right, Jim, would you read the last other business?
The board is to vote for Mr. Scott Goldstein on becoming a full member.
Motion that Scott Goldstein become a full member.
And he'll replace Dick Jotka, who, as we all know, left. I'll second that. All those in favor?
Aye.
Aye.
It's done. All right,
Typical, when they're not here, you vote them in.
there you go.
No choice now.
It's like voting in volunteers.
There you go,
You know, whenever you're at a meeting and, if there's a meeting and you're not there, you get the dirty job.
Yeah, oh, yeah.
That's it. All right, would you like to read the last other business?
Which is,
Approve.
okay,
Okay, who was here for that?
I don't have it.
All right, I'll read it. Approve December 9th, 2015 meeting minutes. I'll make a motion that we
I
do
move.
that.
Hold it. Can't vote on it if you weren't here, unless
I
you've
was here.
reviewed it.
No, were you part of the group?
December 9th, yes.
I was an associate, actually.
If
we
you were
switched
present,
off.
you can vote on it, can't you?
Yeah.
We changed. He was sometimes taking someone's place.
As long as you were,
long as you were
as long
present.
as you were present,
I was
you can
present.
vote on it.
We were both present.
So I'll make a motion that I can't make the
I
motion.
make a motion that we approve the December 9th minutes.
I'll second it. All those in favor?
Aye.
All right. Dom, would you like to make the next motion?
I make a motion that we adjourn.
I'll second.
All those in favor? Aye.
Against?
Good night.